Okay, there's a few more brief points I would like to make. Sorry, because I do not have the time to cut and paste videos like Amos Yee does. He does have a script. His videos are scripted. You can look at his script on WordPress, on his blog. Okay, so another point to make is that some people, the PP has actually stood down the charge on Protection of Harassment Act. As I've said many times, and I'll say it again, I think that the Protection of Harassment Act is uncertain in its application. This will be mitigated by case law, but at the moment, I think it's really uncertain and it's really harsh. I mean, one questions the rationale behind the Protection of Harassment Act. So, because when you think of harassment, you usually think that it's private individuals harassing each other. But if we look at how the Protection of Harassment Act is phrased, it can be used very broadly in the sense that the government can be harassed. And I read somewhere, I do not know if it's true, that the Ministry of Defense has actually used the Protection of Harassment Act. So I'm really curious how the Ministry of Defense could actually be harassed by the population. I thought it's the other way around. Or, I mean, one would think of harassment as between private parties, right? Okay, another point to make, which is that some have commented that the Sedition Act and not just the Sedition Act, Section 298, I think, of the Penal Code, which is to preserve religious harmony in Singapore. Some have suggested that it's time for all these laws to go. In fact, Roy Nung has suggested this, that UK has abolished this recently. In fact, all this has got to do with the European Convention of Human Rights, which most UK judges and most people are not really, most judges and academics are not really happy with the European Convention of Human Rights, which was brought in by the Human Rights Act in 1998, I think, by then PM Tony Blair. So I think not everyone was really happy with the protection of human rights that was accorded, because it was seen to be causing a lot of disruption to the administrative and constitutional framework of the UK justice system. So it's not necessarily good that such laws were abolished in the UK. Probably it was more of a forced. It was forced, and the judges had no say about this. The HRA that was passed, which brought in the ECHR to effect. In other words, in Singapore, we are looking at a very autochthonous system, and we should be looking at a balancing of. We are looking at the balancing of rights, political liberties, and civil liberties, together with the other side of the coin, which is the other side of the picture, which is actually to protect against to protect our freedom of speech. Sorry, I mean to protect against. Sorry, I lost that. Yeah. So on one side, you're protecting political liberties and civil liberties, which is like freedom of speech, and on the other hand, you want to ensure that we have peace in our country. Yeah, we want to ensure that we have peace in our country. We want to ensure that there's religious harmony. We want to prevent the repeat of the Murrah Hertog riots in the 1960s. We want to have that social fabric in Singapore, especially since we're a really diverse and multicultural, multi-religious country. Okay, sorry about the sleep. It's really late at night and I have no script. Okay, I'm going to pen here. There's no script. I'm going to pen here. There's no script as well. Alright, so yeah. What else do I have to say? I think that's all. I'm really interested to see how a better balance could actually be brought between these two sides of the Libra scale. And I also like to comment that freedom of speech is not absolute, and in all countries, freedom of speech is not absolute, it's subject. In fact, in Singapore, Article 12 of the Constitution, which I think was heavily influenced by Ms. Lee Kuan Yew, it actually says that we, in Singapore's citizens, we have freedom of speech, but it is subject to what? It's subject to whatever laws that is validly passed by Parliament. So yes, if you're not happy with the Sedition Act and whatever laws that restrict the freedom of speech, then there's two possible solutions. One is we could do it the court way, the judicial way, which is that the Court of Appeal or probably even a High Court judge could actually override such laws on the basis that they violate natural laws, that they go against the notion that laws should be just, and that this idea of natural law, which is that law should be just and proper, and should be this basic threshold of law, okay, that it must be proper and just and fair, okay. So if it doesn't even meet this minimum threshold, then such laws are actually not natural, they're unjust, and can be struck out under the Ong Ah Chuan case, the dicta, which is I think by Lord Diplock. Yeah. Okay. So that is a very narrow way in which we can actually get by that, by saying that such laws should be struck out because it's totally, it violates our conscience. And also we can look at the Court of Appeal case of Cheng Shangzi, where the court pronounced that all powers have legal limits. So yeah, Parliament cannot do as it wants to and just enact laws that are of a Hitler dictatorship kind of law. And really look forward to the decision by the court, and whether there was some balancing involved, even though the district court does not really have to. I mean, it's the part of the high courts to look at such matters, and this is not a constitutional challenge, but it will be a more complete judgment if it actually looks at if it actually performs a balancing act between civil and political liberties on one hand, and communitarian values and peace and stability in Singapore, economic progress on the other hand. Okay, so I'll leave you at that. When the written judgment comes out, I'll just give a quick outline. I'm sorry for exceeding the time. Thank you.